We now go to rape. Articles 266-A, -B, -C, and -D are all rape. There are three kinds of rape. This was stated by the Supreme Court in the case of People versus Jumawan. Supreme Court said the three kinds of rape are: first, we have rape by carnal knowledge, rape by sexual assault, and the other one is marital rape. So the first one is rape by carnal knowledge. Rape by carnal knowledge is present when the following elements are present. First, that the offender is a man and the offended party is a woman. Second, that the offender had carnal knowledge of the woman against her will. And third, the said carnal knowledge was attended by any of the following circumstances: by using force, threat, or intimidation, when the offended party is deprived of reason or otherwise unconscious; by means of fraudulent machination or grave abuse of authority, when the offended party is under 12 years of age or is demented, even if none of the circumstances I previously mentioned is present. So in case of rape by carnal knowledge, the law specifies who is the offender. He must be a man. And who is the victim? She must be a woman. The victim must be a woman. And the carnal knowledge is against the will of the woman because it was attended by any of the circumstances stated in Article 266-A. How about rape by sexual assault? This is also known as rape by instrument. Rape by sexual assault has the following elements. First, that the offender is any person and the victim is any person. That the offender commits any of the following acts of sexual assault. First, by inserting his penis into another person's mouth or anal orifice, or by inserting any instrument or object into another person's genital or anal orifice. Third element, that the said act of sexual assault is attended by any of the following circumstance: by using force, threat, or intimidation, when the offended party is deprived of reason or otherwise unconscious; by means of fraudulent machination or grave abuse of authority, when the offended party is under 12 years of age or is demented, again, even if none of the circumstances I previously mentioned is present. So in case of rape by sexual assault, the offender can be any person, and the offended party can also be any person. Therefore, it could be a man to a woman to a man. It could be a woman to a man to a woman, because it is any person to any person. And the sexual assault, the insertion of a penis into another person's mouth or anal orifice, or the insertion of any instrument or object into another person's genital or anal orifice. Again, it must be attended by the circumstances I mentioned to show it is against the will of the said other person. If what has been inserted instead of an instrument is a finger, the offender inserted the finger into a child's, into a person's genital, into a person's anal orifice. The crime committed is rape by sexual assault. Supreme Court said a finger is within the meaning of an instrument or object insofar as rape by sexual assault is concerned. The third kind of rape is marital rape. When a husband had carnal knowledge of his wife against the will of the wife by using force, violence, and intimidation on the said wife. In the case of People versus Jumawan, the Supreme Court said, rape exists even in case of marital relationship because rape is a violation of the human dignity of a woman. And such attack on the human dignity of a woman happens even in case of husband and wife relationship, even in case of marital relationship. So those are the three kinds of rape. The father had carnal knowledge of the said daughter. In the said carnal knowledge, the daughter did not put up any kind of struggle The father did not employ force. The daughter was fast asleep. Here comes the father. The father undressed the daughter and had carnal knowledge of her. The daughter did put up struggle. She was simply there lying and crying. And the father had carnal knowledge of her, not employing any force at all. But the daughter informed her grandparents, and they filed a case of rape against the father. The father argued. The daughter consented. She didn't put up a struggle. Is the father liable of rape? The father is liable of rape. In case of a father having carnal knowledge of his own daughter, in case of incestuous rape, you do not look for violence, threat, or intimidation on the part of the offender father. You do not look for any act of struggle on the part of the offended daughter. Because in case of incestuous rape, a father having carnal knowledge of his own daughter, what takes the place of violence, force, and intimidation is the overpowering and overbearing moral ascendancy and influence of the father over the daughter. Hence, rape is still committed even in the absence of struggle and use of force. And in the case of People versus Hawson, Supreme Court said this applies even in case of a brother having carnal knowledge of his own sister. This rule on having moral ascendancy, moral influence applies even in case of a brother having carnal knowledge of his own sister. What if the woman is known in this community to be a mental retardate? She is already 25 years old, but she is clinically diagnosed to have the mental capacity only of an 8-year-old child. She just roams around, no family. She's very dirty, she sleeps everywhere, snatches food from any person, and they just allow it because they know she is a mental retardate. One time, this woman was near the store, and she was sleeping on the ground. Here comes W, one of the persons living in the community who know that she is a mental retardate. W at the time, drunk, a little bit drunk, went to the said woman and told the woman to go with him. First, she gave the woman candies. And then she gave the woman chocolates, and indeed, the woman went up to him, and together they went to the house of W, and there, W had carnal knowledge of this woman. Because of the blood on the dress of the woman, when the barangay captain saw the woman, he inquired from the woman what happened to her. And the woman narrated to the barangay captain what W did to her. A case of qualified rape was filed against W. The information alleged W, the accused in this case, has carnal knowledge of this woman, who is a mental retardate, 25 years old, yet with a mental capacity based on clinical diagnosis to have only the mental capacity of an 8-year-old child. Therefore, the carnal knowledge was against the will of the said woman, period, contrary to law, and then signed by the public prosecutor. That was the information filed before the court. Trial on the merits ensued. During the trial on the merits, it was proven that the woman was a mental retardate. If you were the judge, would you convict the accuser's charge of qualified rape? If you were the judge, you have to downgrade the crime only to simple rape and not to qualified rape. But what if in the information it was alleged that this accused had carnal knowledge of this woman, 25 years old, but a mental retardate, with a mental capacity only of an 8-year-old child, and this accused knew of the mental retardation of the said woman prior to and at the time of the said act of rape. Contrary to law, signed by the public prosecutor. During trial on the merits, Knowledge on the part of the accused that the woman was a mental retardate was proven beyond reasonable doubt. And based on the medical certification, it was proven she is a mental retardate. If you were a judge, would you convict the accused's charge of qualified rape? This time, yes. Rape of a mental retardate, rape of one who is deprived of reason, rape of one who is demented, rape of an unconscious is only simple rape. What will qualify it, what will make it qualified rape, wherein the imposable penalty is death penalty under Article 266 is the fact that the offender knew of the mental disability, mental retardation of the said victim, and such knowledge on the part of the accused was alleged in the information and proven during trial. That is what will make the crime qualified rape. Absent that, it will only be simple rape. The girl is 10 years old. She goes to school. During break, she would leave the school and she would always go to this nipa hut. In this nipa hut, there was this man whom she calls uncle. And during this break time, this uncle would always have carnal knowledge of the said girl. And it was with the consent of the girl. Because after the carnal knowledge, the man would give the girl 10 pesos. And the girl would be very happy going back to school. So one time, it happened again. During break time, the girl went to the nipa hut. The supposedly man whom she called uncle had carnal knowledge of her. After that, she was given 10 pesos. She went back to school. But the teacher noticed something on the dress of the girl. And so they brought the girl to the office, and they saw some semen on the private part of the girl. The girl was brought to the doctor, and it was discovered that the said girl, there was carnal knowledge on the part of the said girl. And the girl narrated what she was doing. This 10-year-old girl what she was doing every break time. And she was able to narrate 5 instances wherein the supposed to be uncle had carnal knowledge of her during break time with her consent because she's given 10 pesos. What further crimes should be filed against the said supposedly uncle the accused? The said uncle the accused should be charged with 5 counts of statutory rape. The victim is under 12 years of age. The Supreme Court said in the case of People versus Gutierrez, in case of statutory rape, there are only 2 elements that need be proven. First, the age of the victim, that the victim is under 12 years of age. And second, the fact of carnal knowledge. And these 2 elements are both proven. There is no need to prove the presence of violence. Because even if the girl consented, since she is under 12 years of age, such consent is immaterial. Because criminal law presumes he has no intelligence of her own to give a valid consent. Hence, it amounted to statutory rape. And one act of rape, one act of carnal knowledge, equals 1 count of rape. Since the girl was able to narrate and prove 5 acts of carnal knowledge, therefore it amounted to 5 counts of statutory rape. Under Article 266-B, in the following instances, the penalty for rape is qualified to reclusion perpetua to death. When rape is committed with the use of a weapon, it is not only simple rape, because the penalty now will be reclusion perpetua to death. Or, when rape is committed by 2 or more persons, the penalty now is reclusion perpetua to death. Or when by reason or on the occasion of rape, the victim becomes insane, the penalty now is reclusion perpetua to death. Or when rape is attempted and a homicide is committed by reason or on the occasion thereof. In these instances, the penalty will be reclusion perpetua to death. In case of rape, we have 2 special complex crimes. Under Article 266-B, when rape is attempted and a homicide is committed by reason or on the occasion thereof, we have the special complex crime of attempted rape with homicide. And the other one, when by reason or on the occasion of rape, homicide is committed, we have the special complex crime of rape with homicide. Attempted rape with homicide is punished by reclusion perpetual to death, while rape with homicide is punished by death penalty. These are the two special complex crimes. The law used the phrase when by reason of or on the occasion of rape, homicide is committed. Supreme Court said, when you say by reason of rape, homicide is committed, it means the criminal intent of the offender is to rape the victim. And in the course of the rape, he had to kill the very victim of the rape. The law also used the phrase, on the occasion of rape, homicide is committed. This means the criminal intent of the offender is to rape the victim. And in the course of the said rape, on the occasion thereof, he has to kill someone, regardless of whether that someone is the victim of the rape or another person. For as long as the said killing took place on occasion of the said rape, the crime committed would be rape with homicide. So in rape with homicide, attempted rape with homicide, the victim of the killing, the victim of the homicide need not be the victim of the rape because of the phrase, on occasion of rape, homicide is committed. There were two women, and these two women were walking along the rice paddies. They want to go to the poblacion. They want to go to the poblacion because they were informed that there was this company that was needing factory workers and they would be applying. However, while these two women, X and Y, were walking along the rice paddies to go to the poblacion, suddenly a man, W, appeared and waylaid them. W all of a sudden gave a strong punch on the chest of both women. Of course, both women felt weak, and as a result, these two women were brought by the said man behind a vacant building. And there, the said man first pinned down the first girl, X. He pinned down the first girl, undressed the girl. And he was about to have carnal knowledge of this girl after undressing himself. But suddenly this second girl, this second woman, Y, began shouting, crying for help. And so what the man did, he hit and hit Y with a lead pipe until Y died. The moment Y died, the man went back to X, who was still on the ground, feeling weak. And the man hit the said woman X with a lead pipe and thereafter had carnal knowledge of X against the will of X by employing force. After the carnal knowledge, the man again hit and hit X with a lead pipe and thereafter left thinking X died, but X survived. And so, the man was prosecuted for two crimes. One is rape and the other one is murder. Rape for having carnal knowledge of X against the will of X, and the other one is murder for killing Y. Are the charges correct? The charges are wrong. The crime committed would be the special complex crime of rape with homicide. Therefore, only one information should be filed in court. The criminal intent of the man was to rape the said victim. In fact, after punching the said victim, he undressed the victim, pinned down, and he was about to have carnal knowledge. But this other woman cried, and so he has to kill the other woman. The said killing took place on the occasion of the said rape. And even if the person killed is different from the person who is raped, since the said killing took place on the occasion of rape, the crime committed would be rape with homicide, a special complex crime punishable by death penalty. The woman worked overtime. It was a Makati office. She went out the building 12 o'clock. And thereafter, she was walking. There was this vacant lot wherein a building was being constructed. She was walking to the bus station in order to get a ride for home. As she was walking, there were 3 men, construction workers, who were having a drinking spree on the said vacant lot. And as she was walking, the 3 men took notice of the said woman. And so the said 3 men ran towards the woman and surrounded the said woman. The said 3 men undressed their shirts. And they were laughing at the woman, and thereafter, all of them pinned the woman down. Thereafter, the woman saw an opportunity. The woman tried to run away. However, one of the men, Z, was able to catch up with her, and thereafter hit or attack or stab her right leg with a knife. She was again pinned down. She was forcibly undressed by the 3 men. The 3 men undressed themselves, and one of the men, X, placed himself on top of the said woman and was about to insert his penis on the woman's genitalia, but the woman was able to struggle and push the man and run away again. But this time, all 3 of them ran after her, were able to catch up with her, and she was stabbed repeatedly. What crimes had been committed by the men? What was the intent? The intent was to have carnal knowledge of this woman. Was the carnal knowledge consummated? It was not. Therefore, the crime committed is attempted rape. By reason, on the occasion thereof, the said woman was killed. Therefore, what is the crime committed? Attempted rape with homicide. Here, the said killing took place by reason of the said rape. Hence, the crime committed is under Article 266-B, attempted rape with homicide punished by reclusion perpetua to death. The three girls were in the park, and while these 3 girls were in the park, the barangay tanod went to the 3 girls. The barangay tanod said, "It is already 11 o'clock, girls. You are violating the curfew hour. There is an ordinance against curfew. Therefore, we are bringing you to the barangay hall." These girls, X, Y, and Z, were so afraid. Y and Z were able to run away, but X failed to run away. And so, X was brought to the barangay hall. There was the barangay chairman. The barangay chairman only gave information to her about, lectured on her about the ordinance, and told her not to do it again, and the barangay chairman told the barangay tanod, "You can bring her home. She will not do it again." One of the barangay tanod A, told the others, "I will be the one to bring her home." And so the others believed that A would bring her home. And so barangay tanod A told the girl to board his tricycle, which the girl did, and he would be bringing her home. When they were on the bridge towards home, the tricycle stopped. And the barangay tanod, with the use of a knife pointing at the girl, told the girl to undress herself. Afraid, a knife was pointed at her. So, she had no recourse but to undress. The barangay tanod also undressed himself and inserted his penis into the girl's genitalia. After that, the barangay tanod pulled out his penis. 5 minutes thereafter, the tanod again inserted his penis into the girl's genitalia. Later, the tanod again pulled out his penis. 5 minutes later again, for the 3rd time, the tanod inserted his penis, and thereafter, satisfying himself, pulled it out again. Thereafter, she told the girl to dress up, and she brought the girl home. The barangay tanod was charged with 3 counts of rape. She, however, argued that if ever he is liable of rape, it should only be 1 count of rape. Is she liable of 3 counts of rape, or is he liable of only 1 count of rape? Supreme Court said he is liable of 3 counts of rape because there are 3 criminal intent to have carnal knowledge of the said girl. Each act of penetration took place at the interval of 5 minutes. Therefore, that means these 3 acts of penetration represents 3 criminal intent to have carnal knowledge of the said girl. Therefore, he was correctly charged and convicted for 3 counts of rape. In his appeal, he cited the case of People versus Aaron. Because in the case of People versus Aaron, although there were 3 penetration, the Supreme Court convicted the accused only of 1 count of rape. But the Supreme Court said, this case of People versus Lucena is very much different from People versus Aaron. In People versus Aaron, there was only 1 criminal intent, although there were 3 penetration. Hence, there is only 1 count of rape. The woman filed a case of rape against 2 men. The 2 men were arrested and they were charged in court. Based on the sworn statement of the woman against this man, she was watching a game, she was watching a beauty contest in their barangay, when suddenly this first accused ex approached her and forcibly took her, brought her to an ipahat, and thereafter had carnal knowledge of her against her will. Thereafter, according to her in the sworn statement, 3 men arrived. And when these 3 men arrived, A left, or X left. The man left. And this man, according to her sworn statement, tried to have carnal knowledge of her. But she was able to run away, and she went to the house of a person by the name of Z. And she asked the help of Z, and Z told her son, why? To bring the girl to her parents' house. At first, Y was hesitant. Y told her mother she doesn't want to bring this girl. But the mother prevailed, and so Y had no recourse but to accompany the girl home, the woman home. But before they reached home, the girl, however, said that she doesn't want to go home. She wanted to go to the house of her auntie. But Y said, if that is the case, then I will no longer accompany you. But at that particular moment, Y forcibly held the hands of the said woman, and thereafter brought the woman in a place and had carnal knowledge of the said woman. So this was the sworn statement. So the case was filed. During the testimony, this was the statement of the woman. The woman said that, well, she was watching this beauty contest. She was there. She felt the need to answer the call of nature. And so she was looking for a restroom. While she was looking for a restroom, here comes X. X there. She could hardly see the face. There was X, and X forcibly grabbed her and brought her to a nipahat, and there had carnal knowledge of her. And then, thereafter, according to her, the said X left, and she went to the house of Z, and then Z told her son to accompany her. And then according to her, on their way, the said man, Y, also had carnal knowledge of her. That was her statement, this time in the direct testimony in open court. So these accused, both X and Y, were convicted by the trial court. CA affirmed the conviction. When the case reached Supreme Court acquitted both men, and it is in this case of People versus Almera, wherein the Supreme Court for the first time disregarded that the so-called women's honor theory, women's honor principle. In rape cases, usually, Supreme Court said, a rape victim, when it is the word of the rape victim versus the word of the accused, law will always favor the rape victim because of the so-called women's honor doctrine or Maria Clara doctrine. A woman who is the victim of rape will not subject herself to be placed in the witness stand, saying or narrating to the court her traumatic experience of rape unless it is true. But this time, in the case of People versus Almera, the Supreme Court now abandoned the so-called Women's Honors Doctrine or the so-called Maria Clara Doctrine. Supreme Court said the testimony of the girl is not straightforward and not convincing to the court. There were so many inconsistencies between her statement on the sworn statement and her statement during the direct testimony. In fact, if you will read the case, in the direct testimony, the girl could not recall the face of the man. Totally very different from that in the sworn statement because she has been repeatedly saying, or siguro, masyado lang magaling ang counsel ng defense. If you will read, ang gandang basahin nung the way he cross-examined the woman. Napa-oo niya na pa-oo. So, umoo siya ng umoo, hindi niya alam, tumatumbling na ang kanyang direct testimony. Because the cross-examination was able to prove that this girl could not determine the man. So how come this man was arrested? How come this man was charged? Because the defense counsel was able to prove that because of the darkness of the night, the woman has been repeatedly saying, hindi ko nakita yung face. Wasn't able to recognize the face. So because of that, because of the many inconsistencies, in this case, the Supreme Court abandoned the so-called Women's Honor Doctrine. So does it necessarily mean that now the Women's Honor Doctrine is already abandoned? I don't think so. What I believe is that in this case, the testimony of the woman was not straightforward, was not convincing. And that is the reason why this doctrine was abandoned. But the moment the testimony of the woman would be convincing, straightforward, and is in accord with reality, still, there can be conviction based on her word as against the word of the accused. Because this Women's Honor Doctrine can only be used if this is the word of the woman versus the word of the accused. Usually, those of the woman would be upheld and believed by the court, but not this time. But I think, again, if the woman's testimony would be straightforward, convincing, again, the Supreme Court will apply the Women's Honor Doctrine or the so-called Maria Clara Doctrine. The information, the accused was charged with a crime of qualified rape. In the information, it was alleged that the said accused was the stepfather of the girl, and the girl is a minor. And in the information, the said qualifying circumstances of relationship and minority were both alleged. During trial on the merits, however, the minor could not remember her age. And the birth certificate, although it was attached to the formal offer of exhibits, was not presented in court to be identified by any witness. Insofar as the relationship is concerned, the relationship alleged in the information was that of a stepdaughter-stepfather relationship. But during the trial of the merits, in the direct testimony and cross-examination of both the girl, the victim, and the accused, they both stated there was no marriage between the mother of the girl and the father. So, what crime has been committed by the accused? Is it qualified rape? It is only simple rape. Although under Article 266-B, the presence of the twin qualifying circumstances of minority and relationship would qualify the act of rape to qualified rape with a prescribed penalty of death, both twin qualifying circumstances of relationship and also minority must be proven beyond reasonable doubt. And in this case, they were not proven beyond reasonable doubt. Minority was not proven because there was no proof that the said girl was indeed a minor at the time. She could not remember her age, her birthday, the birth certificate was not produced in court. Insofar as the relationship is concerned, The relationship alleged was that of a stepdaughter, stepfather, yet, during trial, what was proven was common law relationship. Hence, the crime committed is only simple rape and not qualified rape. The boy had a friend, a 31-year-old man. In fact, the man was his textmate. The man was from the province. The man arrived in Manila. The boy requested her mother to fetch the man as he has nowhere to go. The mother did as what the boy requested. The mother fetched the man at the pier, brought the man in the house, allowed the man to sleep in the house. While they were sleeping, the boy was awakened. There was pain on his stomach. When he looked, he saw that the penis of the man was inserted inside his anus. He cried. The man removed his penis and fondled the penis of the boy. Thereafter, the boy ran towards the mother, and the mother went to the chairman to file a case. The said accused was charged with a crime of rape by sexual assault. What crime has been committed by the said accused? The crime committed by the accused is rape by sexual assault in relation to RA 7610. The victim, the boy, is less than 12 years of age. And the said act of inserting his penis inside the anal orifice of the said young boy is also an act of lasciviousness. Therefore, it falls under Section 5B of RA 7610. Hence, the crime committed is rape by sexual assault in relation to RA 7610. What is the importance of saying that it is in relation of RA 7610? Because rape by sexual assault under Article 266-B is punished only by prisión mayor. But if the victim is under 12 years of age, under Section 5, letter B of RA 7610, the penalty will be reclusión temporal in its medium period. So the purpose of saying that it is rape by sexual assault in relation to RA 7610 is to increase the imposable penalty. It is in this case of Recalde versus People, wherein the Supreme Court said also that one of the contention of the accused was that there were discrepancy, inconsistency in the testimony of the boy. Sometimes the boy would say the penis was inserted. Sometimes the boy would say he does not know. He was not sure whether it is the penis that was inserted inside his anus. And so because of that, the argument of the accused, since the boy could not identify what was inserted inside his anal orifice, therefore, it cannot be rape by sexual assault. Supreme Court said, the law does not give the victim the burden of proving what was inserted inside his anal orifice, because the law says any object or instrument. So for as long as something is inserted inside his anal orifice, then it is already an act of assault. The accused also argued that the said boy was also inconsistent in his testimony because the said boy was not sure if there was a complete or full penetration of the penis on the anal orifice. It is in this case wherein the Supreme Court said that if in case of rape by carnal knowledge, the slightest penile penetration already consummates the crime of rape by carnal knowledge, by analogy, in case of rape by sexual assault, the slightest instrument penetration into the genital or anal orifice of a person will already consummate the crime of rape by sexual assault. So just the same, there need not be full or complete penetration. Under Title 9, crimes